Hello, ladies and gentlemen, and welcome to this court case overview. This is where we cover key Supreme Court cases that you need to know for the AP test. And today we've got McDonald versus Chicago. Now, on its surface, this case, especially if you're, just studying it on your own, might seem like a cut and dry case about self-defense and the Second Amendment. And yes, it absolutely has implications for those things, but you'll see the truth and the application of this case runs much deeper. Let's take a look. To start off, we need to realize that the Second Amendment is uniquely complex among all of the amendments in the Bill of Rights or the Constitution as a whole, because the text of the Second Amendment has this dependent clause at the beginning that really, over the centuries of American history and legal tradition, has caused a lot of headaches in interpreting the second part, the part you're more familiar with of the Second Amendment. That's that first part, a well-regulated militia being necessary to the security of a free state. Then we get to the part you're probably more familiar with, the right of the people to keep and bear arms shall not be infringed. And in the case of McDonald versus Chicago, fully Otis McDonald versus the city of Chicago, this is one of the most recent court cases in the entire course curriculum, a 2010 case. Well, there's really two things that come to a head. First of all, there was this precedent just a couple of years before, Heller versus District of Columbia. And this second part of the phrase, the right of the people to keep and bear arms, is confusing because it makes us wonder, does this militia, is that the only place where we get to keep and bear arms? Well, in Heller versus District of Columbia, the Supreme Court said no. The Second Amendment extends to this idea of self-defense. You have the individual right to own a gun. However, when we start to look at the state and the local level, we wonder if self-defense and the individual right to own a gun are fundamental rights. Since they are not really obviously stated in the Second Amendment, they are only implied by the Second Amendment. And so this led to some particularly interesting debates, in this case, McDonald versus Chicago. Now, the core issue in the year 2010 was this. There was a man named Otis McDonald, and Chicago had banned all people in the city from owning a handgun for any reason. Now, part of Chicago's argument was that they didn't ban all guns. For instance, you could keep a rifle for hunting and you could keep it disassembled in your house. And so they said they're not completely ignoring the Second Amendment, but Otis McDonald didn't believe that was enough. He wanted a handgun for self-defense. His home there in Chicago, it had been broken into 5 times. He wanted to be able to defend himself. The Supreme Court agreed. They thought that Chicago's law was unconstitutional. And this gets into the rights and limitations on states and cities. They said the individual right to own a gun cannot be infringed by state and local governments. Just as in Heller versus District of Columbia, they ruled that the federal government could not limit that right. What this really did, if you've been paying attention to this idea of selective incorporation, is that this incorporated the Second Amendment. You see, this case very quickly at the Supreme Court gained a lot of significance because it went from just another Second Amendment case to a selective incorporation case. And this case is the best example you have in the entire curriculum of a selective incorporation case. So what is that? Let's just cover that pretty quickly. Well, selective incorporation, that's a key vocabulary word for the AP test, is the process of applying limits in the Bill of Rights to state and local governments. Remember that when the Bill of Rights was written, it was meant to apply to the federal government. What's the first word of the First Amendment? Congress shall make no law. And so there was a debate for hundreds of years in our country over, do states have to follow this? Do cities have to follow this? And in the case of McDonald versus Chicago, the Second Amendment was resolved that yes, state and local governments also need to follow the Second Amendment. Now, selective incorporation is a very complex legal doctrine. So what do you need to know about it? Well, you need to know that who is it that gets to rule on selective incorporation? The Supreme Court. The Supreme Court gets to interpret the Constitution, so they get to determine whether a right is fundamental enough to be incorporated to state and local governments. Why do they get to do this, or why does selective incorporation happen? Well, remember, the 14th Amendment, when it was ratified, included not only equal protection, but this idea of due process. Due process being a very broad term, really meaning fairness. And in this case, fairness as carried out by the states. your fundamental rights should not change when you go from one state to the other. And so over time, the Bill of Rights has been incorporated to also apply to states and cities like Chicago. So Otis McDonald won this round, and what does that mean for us? Well, this is a very unique case, and as such, the College Board has never, to my knowledge, released practice or actual questions asking you to do a Supreme Court application on this. Why is that? Well, this case is unique in that I think you could go almost unlimited different directions in talking about why it matters. Obviously, there's the obvious implications. This is a case about the Second Amendment and the individual's right to bear arms, of course, but it's also the only selective incorporation case you're going to look at. So they might ask you to compare it to a case maybe like Gitlow versus New York, which if you have an AP Gov textbook, certainly it will talk about that, even though it's not part of the curriculum. Last, many people see gun rights as a new frontier of civil rights, not civil liberties. Consider that Otis McDonald, he was an African-American man, and he was arguing about safety when he believed the government was not protecting him. And so many people think, especially when you consider the fact that the strategy legally in McDonald versus City of Chicago, well, the person, Alan Gura, who is the lawyer who helped argue this case, he modeled his strategy off of the strategy in Brown versus Board of Education. So some people would say McDonald versus Chicago is even a civil rights case. The point is, you could be asked a lot of different things about this case, and so it's one that you should definitely know well. Thanks for tuning in today. I hope you have an absolutely excellent rest of your day. Best of luck.